Seated.
Announcements.
Honourable members, I have to inform the House that Mr. Niteshan Tailame has joined the clerk's table as clerk assistant. Mr. Tailame joined the civil service as management support officer in August 2014. He was subsequently appointed as court officer at the judiciary in October 2017 and court usher in January 2019. Prior to joining the National Assembly, he held the post of analyst at the Ministry of Finance, Economic Planning and Development. He holds a bachelor's degree in law and management from the University of Mauritius, a Master of Business Administration from the Open University of Mauritius, a Master of Laws in Financial and Commercial Law from the University of Central Lancashire. On behalf of the House and in my own name, I extend a warm welcome to Mr. Niteshan Tailame and wish him a successful professional career. I now invite Mr. Niteshan Tailame to join the table. Honourable members, I have another statement. I have taken cognizance of a press article entitled La sanction contre Rajesh Bhagwan considérée comme injustifiée, which appeared in the Express of today. In the said article, referring to the suspension of Honorable Bhagwan, the Honorable Shakil Mohammed is reported to have stated that I have given a wrong interpretation of standing orders. I wish to set records straight. Honorable members, the House will recall that at the sitting of 5th July 2024, I made an announcement in regard to the intervention of Honorable Bhagwan during a press conference whereby he uttered undignified words to my address. I accordingly requested the Honorable Bhagwan to present his unreserved apologies to the House, failing which I would be left with no other alternative than to ask him to withdraw from the chamber. The Honorable Bhagwan, instead of presenting his apologies, replied the following: I call a spade and I won't withdraw. It is a fact, ou un agent politique, to un agent politique. In the light of the reaction of the Honorable Member, and considering that this amounted to a grossly disorderly conduct and to disregarding the authority of the chair, I took the decision to name him under Standing Order 49-4, and there was no need to proceed under the National Assembly Privileges, Immunities and Powers Act, as grossly disorderly conduct occurred in the House itself. I further wish to inform the House that any member who is aggrieved by the decision of the Speaker may challenge same by way of a substantive motion. Therefore, the remarks made by the Honorable Shakil Mohammed in today's article in Express are not justified. Would the clerk continue with it?
Yes. Questions?
Mr. Speaker, I've given notice of the following private notice question to ask the Honourable Minister of Environment, Solid Waste Management and Climate Change whether in regard to the protection of the environment, he will state the measures he proposes to take following the judgment delivered by the Privy Council in the matter of EcoSud and two other respondents versus the Minister of Environment, Solid Waste and Climate Change and another appellants Mauritius, on the 4th July 2024.
Mr. Speaker, sir, members will recall that during the summing up of the debate on the Environment Act 2024 at Parliament session of the 14th of May 2024, I informed the House that a judgment from the board of the Judicial Committee of the Privy Council was being awaited on this particular case with a view to provide clarification on interpretation of the law regarding the right of appeal by a person to challenge decisions on issuance of an EIE license. The Ministry has never objected to any NGO or aggrieved party to appeal against the decision of the Ministry before the Environment and Land Use Appeal Tribunal. For the benefit of the House, allow me to recall the chronology of events around this issue. On the 23rd of November 2017, my ministry received an application for an environment impact assessment license from Point Destiny Landslide Company Limited for an integrated residential development under the Property Development Scheme on a freehold land of an extent of 709,648.26 meters square at Point Destiny, Beauvallon. The proposed development comprises the construction of the following principal components: 172 villas, 278 apartments and penthouses, 100 duplexes, and 105 service lots with educational, sport, leisure, and commercial facilities. On the 31st of January 2019, an EIE license was issued to the proponent, which was subject to a set of 48 conditions. Allow me here to emphasize that Section 24(3) of the EPA of 2002 provides, I quote, "Notwithstanding the approval of an EIA, the Minister may at any time revoke an EIA license or amend the conditions of an EIA license where he has reason to believe that circumstances reasonably justifying such revocation or amendment of the condition have arisen since the granting of the EIA. The proponent is contravening the conditions attached to his license. Proponent had failed to disclose any material information or had provided false or misleading information in the EIA report." On the 28th of February 2019, EcoSud appealed at the Environment and Land Use Appeal Tribunal against the decision to grant the EIA license to the proponent. The main ground of appeal was that, according to an expert's report issued by the Center for Wetland Research and Training, there were peatlands, that is, terrestrial wetlands, in the proximity of the development site, which have not been identified in the EIA report. Accordingly, the appellant moved that the EIA license be revoked. In August 2021, a preliminary objection was raised by the State Council representing the Minister of Environment, Solid Waste Management and Climate Change, in the same ministry that EcoSud lacked standing under Section 54(2) of the EPA 2002 to lodge the appeal. On the 6th of October 2021, the Environment and Land Use Appeal Tribunal upheld the preliminary objection raised and set aside the appeal by EcoSud on the grounds that the appellant failed to show that it was an aggrieved party and how it suffered undue prejudice from the proposed development. On the 26th of October 2021, EcoSud appealed against the ruling of the ELWAT at the Supreme Court. On the 18th of July 2023, the Supreme Court quashed the ruling of the ELWAT on the basis that the latter had given an unduly interpretation of Section 54(2) of the EPA of 2002 as to who can appeal against the decision of the Minister to grant an EIA license before the ELWAT. In fact, the Supreme Court adopted a more liberal interpretation based on jurisprudence of the British Supreme Court. Consequently, organizations such as NGOs, which allegedly had expertise and sufficient knowledge of the subject matter in which it seeks to protect, may appeal against decision of the minister to issue an EIA license. The case has been remitted back to the tribunal for it to decide whether ECOSUD had sufficient standing under the Act in the light of the principles laid down in its judgment. On the 3rd of August 2023, further to advice of the Attorney General's Office, the Minister and the Ministry of Environment, Solid Waste Management and Climate Change appealed to the Judicial Committee of the Privy Council pursuant to Section 81 of the Constitution of the Republic of Mauritius, and a special leave was granted by the Judicial Committee of the Privy Council. Mr. Speaker, sir, after hearing the case on the 5th of May 2024, the board of the Judicial Committee of the Privy Council delivered its judgment on the 4th of July 2024. In essence, the board dismissed the appeal of the Minister and the Ministry of Environment, Solid Waste Management on inter alia a number of grounds. First, the Environment and Land Use Appeal Tribunal incorrectly required ECOSUD to prove prejudice to its private interests in order to establish standing under Section 54(2)(b) of the Environment Protection Act of 2002. Second, a test of property rights or of economic interest is not appropriate in an environmental context when considering standing under Section 54(2)(b) of the EPA of 2002. The board held that in the environmental context, prejudice in the sense of harm can be applied to an interest in the environment, as well as prejudice to either an economic interest or to a private interest. Third, for that case in hand, the board recognized ECOSUD as an aggrieved party possessing sufficient standing given it has shown genuine concern and interest in the environmental aspects that it seeks to protect, and ECOSUD has showed it possessed sufficient knowledge of the subject matter at hand, albeit no individual property right or interest has been affected. The board observes that ECOSUD has expertise and experience with regard to matters pertaining to wetlands and the region of Point Destiny, and this is backed by an expert's report. Fourth, if prejudice is confined to economic prejudice and prejudice to a private interest, such a narrow interpretation would defeat the larger purpose of the Environment Protection Act of 2002 of protecting the environment, particularly in situations where a proposed development would take place in a private, remote area, which is less likely to impact on an individual's personal interests. Fifth, in relation to the merits of the appeal, the substantive objections raised by ECOSUD are not trivial, frivolous, or vexatious. Rather, the merits are backed by ECOSUD's own considerable expertise and the expert's report. More so, ELWAT did not consider the merits of the claim, including the importance of the issue raised or its consequences. The standing requirement in Section 54(2)(a) should not therefore be used to filter out arguable environmental issues. Furthermore, ordinarily, a hearing on the question of standing should not descend into a protracted preliminary hearing. Last, the National Ramsar Committee's clearance to the development was subject to a condition that the Environment and Sustainable Development Division of the Ministry be requested to undertake an environmental impact assessment on the project. Accordingly, the National Ramsar Committee considered that ECOSUD's objection had sufficient merit to require not only an EIA by the proponent, but also an EIA by the Ministry. I wish to point out that it is not for the Ministry to undertake an environment impact assessment of the project, but the proponent himself. This has been the position of the Ministry before the ELWAT. Moreover, given that the EIA assessment process is multidisciplinary by its nature, the different aspects relating to environment have been duly assessed during the EIA process by various concerned competent ministries. Mr. Speaker, sir, based on those arguments, the board of the Judicial Committee of the Privy Council held that the Supreme Court quash the ruling of the Environment and Land Use Appeal Tribunal and ordered that the matter be remitted back to the ELWAT for it to decide whether ECOSUD had sufficient standing in the light of the principles laid down in its judgment. Mr. Speaker, sir, further to the judgment delivered, I wish to highlight the following. First, this judgment has brought further clarity on what defines an aggrieved party under Section 54(2) of the EPA of 2002, to the effect that an NGO which is able to demonstrate sufficient undue prejudice may challenge the decision to grant an EIA license, although no private or economic interest has been affected. Second, it is important to recall that amendments were brought to Section 54(2) of the EPA Act of 2002 through the Environment and Land Use Appeal Tribunal Act of 2012 to introduce standing requirements to prevent arguably busybodies, that is, persons unduly interfering and unconnected with a project, from abusing the appeal process, thereby causing considerable delay in projects. The judgment relates to the interpretation to be given as to who is an aggrieved person under Section 54(2) of the EPA of 2002 in respect of a NGO, and would not have any impact on this policy of preventing such busybodies to make frivolous appeals against EIA licenses granted to legitimate undertakings that have successfully gone through proper environmental impact assessments. What this verdict of the Judicial Committee of the Privy Council gives is clarity on how NGOs who have no private or economic interest which will be impacted by a project may be able to demonstrate sufficient prejudice to be able to challenge the project by proving that they have a genuine interest in aspects of the environment that they seek to protect, and sufficient knowledge of the subject will be able to show that a decision to approve the issue of an EIA license is likely to cause them undue prejudice in relation to their interests in that aspect of the environment. Third, the judgment highlighted environmental stewardship as one of the strengths of the EPA 2002, which urges every citizen to use his best endeavors to preserve and enhance the quality of life by caring responsibly for the natural environment of Mauritius. I wish to point out to members of the House that environmental stewardship has been maintained in the new Environment Act of 2024 and is a vibrant proof of government's intent to pursue inclusive, good environmental governance. Fourth, as opposed to claims being relayed in the press, the judgment of the Judicial Committee of the Privy Council is in relation to the EPA of 2002, as amended. The Environment Act of 2024 is new, and its provisions have not yet been tested before a court of law. Accordingly, it would be presumptuous to state that the Environment Act of 2024 is undermined in any way. Rather, as previously mentioned, this judgment has brought clarity on interpretation of specific terms in a provision of the EPA 2002 as amended. Fifth, I wish to highlight that the Environment Act of 2024 has already provided for a host of other measures to even further improve environmental governance in the Republic of Mauritius, and which will come into force as from the 1st of August 2024. First, we have the reintroduction of a strategic environmental assessment, whereby government will lead by example by exposing several of its own key sectoral public policies and programs to evaluation of the environmental impacts is an illustration of this. The strategic environmental assessment aims at supporting proactive consideration of environmental and sustainable development objectives at the outset of plans and programs in various sectors such as agriculture, ESAs, fisheries, energy, industry, transport, waste management, town and country planning, developments above 20 hectares, port development, as well as multiple undertakings. A strategic environmental assessment will ensure that environmental considerations are integrated into plans and programs right from the planning stage, and will provide a wider perspective by ensuring that socio-economic issues are treated at par with environmental protection and sustainability. Furthermore, we are also expecting that SEA will be instrumental in the early consideration of potential impacts, precautionary and preventive action principles, including cumulative and synergistic impacts that are often difficult to identify at low tiers and project level. We have also the EIE and PER, Preliminary Environment Report, processing mechanisms, which have been reviewed in depth within the Environment Act of 2024 to ensure and enhance transparency. As from the 1st of August 2024, whereby the Environment Act 2024 will be proclaimed, the public will also be able to submit views and comments on PER applications, as described at Section 34 of the Act. This contrasts with the EPA of 2002, whereby PERs were not subject to public inspection. In order to further enhance transparency, additional information or studies undertaken during processing of EIE and PER applications will be made accessible to the public on the National Electronic Licensing System for consultation. Furthermore, the Environment Act of 2024 provides for improvements in the assessment of environmental integrity of environmental assessments. To that end, and with a view to complete the cycle of environmental assessment, proponents would now be required to apply for a completion certificate prior to operating any undertaking in line with Section 52 of the Environment Act 2024. Moreover, the new Act also provides for enforcing agencies to submit monitoring reports on a quarterly basis. This aims to ensure close monitoring by authorities and regular monitoring thereof. It is to be stressed that, as was the case in the EPA of 2002, the Environment Act of 2024 also provides for the Director of Environment to be able to extend the time limit to submit public comments to afford reasonable opportunity for any person to submit comments on a preliminary environment report, environment impact assessment, strategic environmental assessment, as and when required. Mr. Speaker, sir, allow me to point out that funding has been appropriated in the last budgetary exercise for the ground truthing and finalization of the environmentally sensitive areas, mapping of the following ESAs: coastal marshlands, upland marshlands, mangroves, as well as formulation of policy recommendations with regard to St. John's. Moreover, under the UNDP Global Environment Facility and Government Project on Sustainable Land Management, the draft Environmentally Sensitive Areas Bill of 2009 is being reviewed, and a legal expert has been hired to that end. A revised draft is expected to be formulated by December 2024. Last, it is to be also pointed out that the environment sector is one characterized by its dynamic nature. Hence, new issues or challenges may and will call for frequent reviews and possible legislative amendments. That approach will continue. Thank you.
Can I ask the Minister whether he'll inform us if the National Ramsar Committee is chaired by the Permanent Secretary of the Minister of Agro-Industry? Yes. Now, and he made the request for an EIA to be carried out, and that was set aside. Why is it then that the advice was not sought from the Ramsar Advisory Commission? Then perfectly well that there's encroachment upon the wetlands.
Mr. Speaker, sir, as I mentioned in my main reply, I pointed out that it is not for the ministry to undertake an environment impact assessment of the project, but the proponent himself. This has been the position of the ministry before the ELOAT. Moreover, given that the EIA assessment process is multidisciplinary by its nature, the different aspects relating to environment have been duly assessed during the EIA process by various concerned competent authorities.
Does the minister realize that in taking the lead in the appeal proceedings, he's in a way substituted himself for the promoter whose direct interests were involved?
Mr. Speaker, sir, as I said earlier, we welcome the decision of the Privy Council, as the Privy Council has given a wider interpretation of locus standi in such matters. Had we not appealed on this matter, we would not have had the benefit of having such a broader interpretation of locus standi.
Broader interpretation doesn't mean that government has to side with the promoter. Does the minister realize that in siding with the promoter during the appellate proceedings, both before the Supreme Court and the Privy Council, he was opting for the destruction of pristine environment by the promoter rather than preservation by ECOSID?
Monsieur le Président, je pense que j'ai été très clair dans ma réponse. Hein. Donc, je ne vais surtout pas répéter la réponse que j'ai donnée. Le EI license a été... il y a eu l'application du EI license le 23 novembre 2017. Le 31 janvier 2019, le EI license was issued to the proponent. 31 janvier 2019 was issued to the proponent, which was subject to a set of 48 conditions. Et j'ai mentionné aussi que le 23 février 2019, l'ECOSUD a fait l'appel à the Environment and Land Use Appeal Tribunal. Ensuite, il y a eu le cas devant la Cour suprême, etc. Monsieur le Président, je pense que l'honorable leader de l'opposition doit quand même se rappeler. Il a été lui-même membre et aussi ministre dans le passé d'un gouvernement qui a tout, et dans le gouvernement mauricien, dans le principe démocratique à Maurice, il a toujours existé le principe de la permanence de l'État, et ce, quel que soit le gouvernement ou le ministre qui se succède. Et là, je l'ai mentionné dans ma réponse, que toute la procédure a été suivie. Ce n'est pas une question qui a délivré le PMI, qui est le ministre qui a délivré le PMI, etc. En tant que ministre de l'Environnement, j'assume pleinement ma responsabilité, bien, tout comme le ministère de l'Environnement fait partie du gouvernement, nous assumons pleinement notre responsabilité. Mais permettez-moi aussi de rappeler au leader de l'opposition, hein, je pense que le leader de l'opposition doit aussi se rappeler que, laissez-moi terminer, Monsieur le Président, laissez-moi rappeler au leader de l'opposition, c'était bien en 2012, lorsque lui-même faisait partie du gouvernement, il y a eu l'amendement de l'Environment and Land Use Appeal Tribunal, où, Monsieur le Président, dans le Environment Protection Act de 2002, où, à la section 54, c'est mentionné « Jurisdiction of the Tribunal. The Tribunal shall hear and determine appeals against the decision of the Minister », où c'est dit que, à la section 2, any person, je dis bien, any person may appeal within 30 days of the decision, etc., etc. Ensuite, il y a eu l'amendement de 2012. L'amendement de 2012, précisément, où c'est mentionné, noir sur blanc, that the minister had decided to issue an EI license, any person who is aggrieved by the decision. Aggrieved by the decision and is able to show that the decision is likely to cause him undue prejudice may appeal against the decision of the tribunal. Donc, Monsieur le Président, c'est pas une question de venir dire que la faute impute à tel ou tel gouvernement, etc. Il y a eu des décisions successives qui ont été prises par le Parlement successivement, par plusieurs gouvernements. Nous nous retrouvons dans un cas de figure d'interprétation de la loi. Et moi, personnellement, en tant que ministre de l'Environnement, je suis très heureux que le Privy Council a pu se prononcer sur cette question de locus standi. Et moi, je suis très content que nous avons eu cet avis du Privy Council, Monsieur le Président.
Yeah, but I can't understand why is that the minister has not allowed the promoter to fight its own case before the Privy Council. Why is it that the minister had to side with the promoter, and in doing so, his minister has been complicit in undermining the procedural safeguard of an appeal to the tribunal by allowing the promoter to proceed with the development, as this amounts to a failure to care responsibly for the environment.
Monsieur le Président, il n'est pas normal de dire qu'on est en train de permettre à tel ou tel développement, etc. Mais je dois quand même dire que c'est vrai que le judgment Judicial Committee of the Privy Council mention on works ongoing on the site, mais we take note of remarks need consideration. As far as we are aware, there has not been any formal request of a stay order by ECOSUD before the Supreme Court or before ELOAT. Et je dois dire aussi que le ministère de l'Environnement, the proponent submitted an EMP for approval on the 14th of December 2021. In view of the ongoing court case, the advice of the Attorney General's Office was sought on the 7th of July 2021, whether the EMP can be processed, and the Attorney General's Office informed the 27th of July 2021, provided that there has been no application for stay of the implementation of the project made by an interested party before either the Environment Land Use Tribunal or the Supreme Court, there would not be no legal impediment to proceed with the implementation of the proposed development. Donc, Monsieur le Président, nous ne sommes pas en train de travailler en isolation, mais bien sûr en conformité et aussi en consultation avec toutes les autorités concernées.
Because this is shocking in light of what the minister has said. The case has been heard before the Supreme Court, was pending before the Privy Council, and will eventually be sent back, as he said, to the Environment and Land Use Appeal Tribunal. How could the minister still allow the promoter to proceed with the development? Don't you have some respect, at least for the Supreme Court and the Privy Council in the light of the judgment pronounced?
Monsieur le Président, je vais surtout pas répéter la même réponse que je viens de donner. Je pense que j'ai été très clair dans ma réponse, Monsieur le Président.
I've stated very clearly that action has to be taken, call it stay order. In the meantime, the promoter is carrying on with its work. Why is it that the promoter is allowed to carry on with the work? This goes against what the Privy Council and the Supreme Court has stated. There should be stay of action till the case is referred to the Environment Land Use Appeal Tribunal.
Monsieur le Président, je pense que dans le jugement du Judicial Committee of the Privy Council, cela est clair, que le Judicial Committee of the Privy Council a pris note du fait que le promoteur est en train de continuer son projet. Monsieur le Président, c'est clair dans le jugement que l'affaire sera référée au Environment and Land Use Appeal Tribunal, où l'ONG EcoSud aura l'occasion de venir prouver ses points, défendre ses points, etc. Ce n'est pas à mon niveau de venir préempter, de venir prédire quelle sera la décision du Environment and Land Use Appeal Tribunal. Je pense qu'il faut laisser les différentes instances du pays fonctionner et à la lumière de la décision de l'Environment and Land Use Appeal Tribunal, le ministère sera appelé à prendre toute décision qui s'impose.
Do we have a Minister of Environment or the Ministry and the government pro the promoter? You have wasted more than 5 million rupees of taxpayers' money in an appeal, which had you won would have restricted the citizens' right to protect the environment. Can you inform the House who advised you to appeal against the decision of the Supreme Court, and what was the reasoning which convinced you to do so?
Monsieur le Président, je pense que je ne vais surtout pas répéter la question qui a été dite. Pour nous, c'était important pour nous d'avoir une bonne définition en ce qui concerne cette question de local standby. On a eu la décision du Privy Council. Bien sûr, nous serons toujours guided par la décision du Judicial Committee of the Privy Council. Et bien sûr, l'affaire sera référée au Environment and Land Use Appeal Tribunal. Moi, je pense qu'il va falloir qu'on puisse respecter toute décision qui va être prise par le Environment and Land Use Appeal Tribunal.
Minister,
Has the minister made an assessment of the total cost implied? Total costs that have to be paid to all parties since government has lost the case.
Non. Monsieur le Président, la question de cost n'a pas été soulevée jusqu'à présent. Donc, non, nous ne sommes pas en présence d'aucune indication de ce cas précis, Monsieur le Président.
And to reason that facts are damning, and the ministry has favored the promoter and has not respected the decision.
Honorable Boulel, put your questions directly without any observation, any remarks. Question.
Is the minister aware that in doing so, and by not implementing what the Privy Council has stated, that Mauritius may be considered as a rogue state by allowing those who have flouted the law to get away with murder?
Monsieur le Président, cette question de faire appel au Privy Council. C'est une pratique courante dans le pays, Monsieur le Président. As I said earlier, we welcome the decision of the Privy Council, as the Privy Council has given a wider interpretation of local standard. In such matters, had we not appealed on this matter, we would not have had the benefit of having such broader interpretation. Monsieur le Président, ce n'est pas la première fois que l'État fait appel au Privy Council. Il s'agit d'une pratique courante qui nous permet de faire appel à la plus haute instance juridique du pays, qui est le Privy Council. Dans ce cas précis, cela nous a permis d'avoir une conclusion constructive. Toutefois, il est bon de rafraîchir la mémoire du leader de l'opposition. Dans le passé, dans le cas Point, la Cour suprême avait donné gain de cause à Pravin Kumar Jagnat, l'honorable Pravin Kumar Jagnat, mais le DPP d'alors avait néanmoins fait appel contre le jugement de la Cour suprême aux frais de l'État, aux frais des contribuables, Monsieur le Président. Le Privy Council faut bien le rappeler, a confirmé le jugement de la Cour suprême et donné gain de cause à l'honorable Pravin Kumar Jagnat. Il faut aussi ne pas oublier que la pétition électorale de Suren Dayal, contestant les résultats des élections de la circonscription numéro 8, la Cour suprême avait confirmé qu'il n'y avait aucune maldonne dans le processus électoral. Mais M. Dayal a fait appel au Privy Council avec la bénédiction de son leader, mais nous savons tous que le Privy Council avait confirmé que ces élections se sont déroulées d'une façon free and fair. Ce que je veux souligner, Monsieur le Président, c'est que dans ce cas également, plusieurs instances gouvernementales, notamment l'Electoral Supervisory Commission, l'Electoral Commissioner, ont dû débourser des frais pour restaurer leur image que certains ont voulu tenir, Monsieur le Président. Mais il faut bien que l'honorable puisse savoir cela, Monsieur le Président.
Order. Time over. Prime Minister's question time. The House is informed that PQB 552. Order. Both sides of the House. Order. Your time is finished. Your time is finished. Okay. No. Both sides of the House. I said. At all times, I said. PQB 552 have been withdrawn, so I call Honorable David.
B553.
Mr. Speaker, sir, I wish to refer the honourable member to my reply to parliamentary questions B/989 and B1/1001 on 11th of July 2023 on the revamping of the Mauritius National Identity Card project, and parliamentary question B/1442 on 14th of November 2023 on the use of the new digital identity card in the next general elections. Since the parliamentary question regarding the use of the new digital identity card, which I am informed is the same as the new mobile identity card, has been put again, I will seize this opportunity to provide additional information regarding the mobile identity card and at the same time address the implications regarding the use of the mobile identity card during National Assembly elections. Mr. Speaker, sir, the Mauritius National Identity Card scheme was introduced and implemented in Mauritius in 2013 under a government-to-government agreement between the Republic of Singapore and the Republic of Mauritius. The honourable member would recall that in my reply, I also informed the House that following the private notice question of the then leader of the opposition, Honourable Paul Raymond Béranger, at the sitting of 30th of October 2012, the then Minister of Information and Communication Technology informed the House that in 2009, the State Informatics Limited launched a request for proposal for a new Mauritius National Identity Card project to 7 shortlisted suppliers in accordance with Section 3(1) of the Public Procurement Act, which provides that procurement is to be undertaken by the most competitive method of procurement available in all circumstances. In response to that tender exercise, 3 out of the 7 shortlisted bidders submitted proposals, and the Bid Evaluation Committee recommended that award be made to SAGEM for a value of 7.2 million euros, amounting to approximately 317 million rupees at that time. However, after the visits of the then Prime Minister to Singapore in September and subsequently in December 2010, he gave instruction to cancel the bidding exercise for unknown reasons and to enter into a G2G agreement with Singapore through the Singapore Corporation Enterprise in partnership with Crimson Logic Private Limited for the provision in the first instance of consultancy services for the sum of 10,916,204 rupees. Thereafter, on 17th of October 2012, an agreement for implementation of a new national identity card system was signed between the Government of Mauritius and the Singapore Corporation Enterprise for a sum of 1,111,256,305 rupees as capital cost. So we come from 317 million rupees to 1,111,256,305 rupees. So it is worth noting that the contract signed between the parties contained a non-disclosure clause. Mr. Speaker, sir, following the advice received from the Ministry of Information Technology, Communication and Innovation, that the hardware and software of the former system had reached their end of support and end of life, my government decided in March 2020 to revamp the previous system. Hence, following a bidding exercise launched on 12th of April 2022, the contract for the supply, implementation, operations, and maintenance of a turnkey solution for the National Smart Card-based identity system and a smart app-based mobile ID solution was awarded to the consortium Thales Arel Malak Technologies. The contract was signed on 15th of February 2023 with an implementation period of 1 year for a capital cost of approximately 374 million rupees as compared to the more than 1.1 billion rupees which was incurred in 2013 as capital cost. As such, the new Mauritius National Identity Card system, which was launched on Friday, 23rd of February this year, is aligned with international trends and provides several new facilities. Mr. Speaker, sir, so far, the physical version of the Mauritius National Identity Card 3.0 has been introduced. The mobile ID which is part of the system, will be launched shortly after the final required technical verifications have been completed and the necessary process from Google Play Store and Apple App Store for the publishing of the mobile ID applications are completed. The National Identity Card Unit of my office is working in close collaboration with the Central Informatics Bureau of the Ministry of Information Technology, Communication and Innovation and the consortium Thales Arel Malak Technologies Limited to finalize the coming into operation of the mobile ID. I am informed that same will be stored securely in the digital wallet on a smart device. The digital wallet is a secured application which can be downloaded on a smart mobile device and is used to store digital documents. The introduction of the digital wallet and the mobile ID will complement the advancements in identity card technology, reflecting global trends in mobile-based identity solutions and digital transformation initiatives. Thus, with the implementation of the mobile ID, Mauritius will become the first country on the African continent to bring in a fully interoperable digital ID wallet based on international ISO standards. Similar digital wallets are already deployed in Australia and the United States of America and will soon be introduced in Europe. It is worth noting that our country will embrace this digital wallet app to hold an electronic version of their identity card, that is the mobile ID, even before the European Union, since these ISO-compliant electronic deployments will only start in the EU countries as from 2026 as part of new EU regulations. Thus, the mobile ID, which is the electronic version of the physical ID card, will soon be available on the citizens' mobile devices, enhancing accessibility, security, and usability, and will be one of the digital documents to be stored on the digital wallet. The mobile ID contains the same information found on a physical ID document, but with state-of-the-art security features available through digital technology. In view of the prevalence of smart devices in Mauritius, citizens will be able to use their mobile ID in lieu of their physical ID as a proof of identity. Furthermore, a mobile verifier app would be available free of charge to any citizen or organization to verify the genuineness of the mobile ID. The mobile ID will provide a convenient and secure technology for citizens within an infrastructure which will ensure security, privacy, and integrity of data from enrollment to the in-field verification process. It will also contain several facilities, such as the option of reporting change of address or loss of identity cards. Moreover, it will include digital signing of electronic documents, amongst others. In this context, the National Identity Card Act was amended through the Finance Miscellaneous Provisions Act 2023 to ensure that both the physical identity card and the mobile ID operate within a legal framework. The amended Act provides that the new identity card system shall have the necessary features to ensure the security and confidentiality of information contained therein, and to give the same legal standing to the physical identity card and the mobile ID as proof of identity. Provision was also made in the Act that any citizen registering for a mobile ID shall already be holder of a physical national identity card. Mr. Speaker, sir, moreover, the National Identity Card Regulations of 2024 have been promulgated to regulate the layout of the new ID card and new features such as the option to have digital certificates. In the same vein, the National Identity Card Mobile ID Regulations 2024 were introduced to, inter alia, regulate the use of the mobile ID. Also, a new set of regulations is being prepared by the Attorney General's Office in consultation with the National Identity Card Unit and the Ministry of Information Technology, Communication and Innovation pertaining to card reading. I am further informed that the digital wallet application, which will store the mobile ID in the first instance, will be able to accommodate other digital documents, such as the birth certificate and the marriage certificate. Discussions are ongoing between my office, the Ministry of Information Technology, Communication and Innovation, and other stakeholders to explore the possibility of storing other documents in the digital wallet. The digital wallet is protected by the existing security features on the smartphone of the citizen. Furthermore, the consent of the citizen is needed to access his or her mobile ID. Therefore, the digital wallet will be managed by the citizen himself or herself. Mr. Speaker, sir, as regards parts A and B of the question, I have already stated in my reply to Parliamentary Question B/1442 on 14th of November 2023 regarding the use of the new digital identity card in the next general elections that the Electoral Commissioner has a well-established and regulated procedure already in place for the authentication of voters at the time of voting. Given that this question is coming again, let me remind the honorable member that pursuant to Section 41 of the Constitution, the constitutional powers to organize elections rest in the Electoral Supervisory Commission. Section 41(1) of the Constitution provides that, and I quote, "The Electoral Supervisory Commission shall have general responsibility for and shall supervise the registration of electors for the election of members of the Assembly and the conduct of elections of such members, and the Commission shall have such powers and other functions relating to such registration and such elections as may be prescribed," unquote. Moreover, Regulation 27 of the National Assembly Elections Regulations of 2014 provides that, and I quote, subsection 1, "Every elector desiring to record his vote shall present himself to the presiding officer in the appropriate voting room at the polling station at which he is entitled to vote, state his name, and produce his national identity card or any other acceptable proof of his identity." Subsection 2, "The presiding officer, after satisfying himself that the name of the elector appears on the copy of the part of the register containing the names of electors entitled to vote in that voting room shall, subject to Regulation 29, deliver a ballot paper to the elector. Unquote. Mr. Speaker, sir, as already stated earlier in my reply to Parliamentary Question B/1442 on 14th of November 2023, there is a well-established process for authentication of the voter on the voting day, which is as follows. In order to cast his vote, a voter has to produce his national identity card or passport as acceptable proof of his identity to the presiding officer in the voting room at the polling station where he is entitled to vote. Before issuing a ballot paper to the voter, the presiding officer verifies the ID number and the name of the voter in the presiding officer's copy of Register of Electors. The presiding officer's copy of register contains the surname and other names, NID, address, gender of the elector, and as well the elector's number. And verification if the photo appearing on the national identity card or passport of the voter corresponds with the voter. This physical verification of the national identity card or passport is made to ensure the identity of the voter. I did also make reference to the fact that in both the 2014 and 2019 National Assembly elections, the following documents were used as acceptable proof of identity: national identity card, passport, driving license, and bus pass. Mr. Speaker, sir, Regulation 2 of the National Assembly Elections Regulations 2014 defines acceptable proof of identity as such document establishing the identity of a person as the Electoral Commissioner may, after consultation with the Electoral Supervisory Commission, determine. Thus, based on Regulation 2 of the National Assembly Elections Regulations 2014, the only acceptable proof of identity is, since the Village Council Elections 2020, either a national identity card or passport. This measure was also adopted for the Rodrigues Regional Assembly elections of 2022. Mr. Speaker, sir, the House would recall that I also mentioned that Regulation 30, subsection 6 of the National Assembly Elections Regulations 2014 provides that, and I quote, subsection A, no person shall, by means of 1. A camera, 2. A mobile phone, 3. A photographic or an electronic device or any other device through which a photograph may be taken or film may be made, take a photograph or make a film of a ballot paper, whether the ballot paper is marked or unmarked, unquote. However, I am informed by the Electoral Commissioner that an elector may be in possession of his mobile phone or any other devices mentioned in Regulation 30, subsection 6, in the voting room, but he is not allowed to use same in the voting or counting room. As I have already stated, the mobile identity card is being finalized. However, once it is launched, the possibility to use it for authentication of voters will require, in the first instance, the conduct of a feasibility study regarding, amongst others, manpower and training requirements, equipment including verification devices in the voting rooms of all polling stations, procedures regarding the authentication process, and financial implications thereof. I am informed by the Electoral Commissioner that in view of the wide-ranging implications for the introduction of mobile ID as proof of identity in the voting room, it will not be possible to make use of mobile ID for the coming elections. Thank you.
Merci, Monsieur le Président. J'ai écouté avec attention les 22 minutes de réponse du Premier ministre. Prime Minister stated in his answer, citizens will be able to use their mobile ID in lieu of their physical ID as a proof of identity. And in the meantime, we have now this new mobile ID regulations, February 2024, which states, Section 5E, the mobile ID can be used to authenticate the holder. I have listened very carefully, Honorable Prime Minister, to your last sentence. May I, therefore, ask the Honorable Prime Minister to take a commitment today in this House that no mobile ID shall be used to authenticate at any time any voter in any voting room for the next National Assembly elections.
Monsieur le Président,
Point of
je
order.
pense que peut-être que j'aurai besoin de plus de 22 minutes. Parce que si en 22 minutes, ce que j'ai dit, c'est tellement clair, mais si l'honorable membre n'a pas compris et il me repose la même question, c'est que peut-être que je dois avoir une demi-journée pour expliquer. J'ai bien dit à la fin de ma réponse, let me repeat, et c'est surtout à la fin de ma réponse, I am informed. Ce n'est pas à moi de prendre la décision. I am informed. Je le dis en français, peut-être pour qu'on puisse mieux comprendre. So, I am informed by the Electoral Commissioner, c'est le commissaire électoral, that in view of the wide-ranging implications for the introduction of mobile ID as proof of identity in the voting room, it will not be possible to make use of mobile ID. Ce ne sera pas possible d'utiliser le mobile ID pour aller voter. Qu'est-ce que je peux dire plus que ça? Ben, si vous me donnez la permission, je peux répéter ça en créole mauricien.
Thank you, Mr. Speaker, sir. I pick it from the last sentence that the Prime Minister just mentioned. The Prime Minister mentioned about the wide implications. Can the Prime Minister thus inform the House whether there are technical and legal implications with regards to the use of mobile ID for the purpose of voting? Thank you.
Mr. Speaker, sir, the Regulation 27(1) of the National Assembly Elections Regulations of 2014 provides that, and I quote, every elector desiring to record his vote shall present himself to the presiding officer in the appropriate voting room at the polling station at which he is entitled to vote, state his name, and produce his national identity card or other acceptable proof of his identity, unquote. So, if the mobile ID is to be used and is determined by the Electoral Supervisory Commission to be any other acceptable proof of a voter's identity, it would, of course, then be legally in order to use the mobile ID. However, there are major technical constraints for the use of the mobile ID for the purpose of voting. In order to verify, first of all, electronically the authenticity of voters using the digital identity card. All voting rooms at all the polling stations, and there are around 2,300, will have to be equipped with verification machines. And that entails also financial implications. That is why the Electoral Commissioner has said that for the coming elections, that would not be possible.
His reply, Honorable Prime Minister, mentioned about a mobile ID verifier app. May I know whether the MNIC unit, which falls under the purview of his office, has already procured this mobile ID verifier app?
Well, the honorable member should know according to standing orders. When he puts a specific question with regard to voting at the next general election, he should restrain and limit himself to the questions. Well, leader of the opposition, he's the last one to speak. He doesn't know, not even know how to put questions. So he's making comment.
Order. What is happening, Honorable Tim? Where you're concerned in this?
Yeah.
Can you show me your locus standi? So the table has been advised that PQB 555, 556, 557, 561, 562 have been withdrawn.